SJC-11542, Commonwealth v. Peter Pond.
Yes, counsel, good morning.
Good morning, Chief Justice and Justices of the Court. May it please the Court, my name is Pauline Curian, and I represent the appellant in this case, whose petition to seal his criminal records was denied by the Boston Municipal Court. The goal of the criminal record sealing statute is to promote rehabilitation of defendants and also access to employment, housing, and social contexts to facilitate that rehabilitation. In deciding whether to seal a criminal record, a judge is required to weigh the petitioner's interest in sealing the record against the public's constitutionally based interest in keeping the record open.
And I'd like to explore that part. Your brief laid out beautifully all of the problems with, the not sealing that brings about. But the legislative goal hasn't really changed for 100C since the time that Prokasky took a look at 100C. It's basically the same statute. It allows now for quaffs in addition to other things, but the same substantial justice standard, as I read it anyway. Maybe you'll correct me, maybe it's substantially changed. It seems to me the legislature has had the goal of promoting sealing now for quite some time, but the problem was that the Boston Globe, on asserting First Amendment considerations, said that that statutory scheme was constitutionally problematic, and that subsequently the court, the First Circuit, basically said, that the Commonwealth's interest in sealing is not to be greater weighed than the First Amendment interest in presumptively open court records. So that to the extent that the legislature wants to have sealing be promoted, that's in tension with, isn't it, the First Amendment right of the public to get to criminal records, presumptively open criminal records, the strong presumption of open criminal records.
Well, that's a starting point, but a judge is required to weigh the interests of the defendant versus the First Amendment presumed right of the public to access. I mean, that is where this case went terribly wrong. What the court had before it was the quintessential criminal record sealing petitioner. He had a recommendation from a police officer calling him an inspiration to his community. He had other recommendations and support letters from other community programs calling him a person who makes great contributions to other people. And he also offered ample evidence in that he had achieved sobriety and maintained it for several years. He was underemployed, receiving public assistance, and living in poverty despite his many efforts to get employment. And he was rejected specifically from employment from a school because of his CORI, which naturally included the charges in this case. In contrast, the prosecutor in this case put nothing on the scales in the Commonwealth's favor in terms of maintaining the record open to the public. The prosecutor cited no public safety concerns. The prosecutor didn't even cite a single benefit that would flow from keeping the record open. I'm sorry.
You go ahead. Go ahead.
Judicial discretion is not merely the flip of a coin. As this court noted in Marlowe versus the City of New Bedford, a ruling is clearly erroneous even when supported by some evidence if upon review of the entire body of evidence, one is left with a clear and definite firm conviction that a mistake has been committed. That is this case. This should have been a simple case for the judge. The judge erred in denying the petition to seal the criminal records in this particular instance. And to address the earlier point as to has anything changed, I would say yes, many things have changed societally, and as well as legislative changes have occurred since the almost 20-year opinion.
But 100C hasn't changed.
Well, it has changed because there is a new provision in 100C that specifically allows people whose cases were continued
Right,
without
but
a
other than
finding
that, other than
from
that.
probation.
And
No,
in fact, isn't there some reason to think that the first paragraph of 100C is not even constitutional?
well, the legislature either didn't know about the case law or wanted, or affirmatively rejected the case law in terms of the constitutional parameters because it didn't address that issue, and it remains intact. It continues to say that if someone, if a case ends in a not guilty finding, that it's automatically sealed.
Do we have a jurisprudential disconnect in that when we discuss the impoundment of criminal records, we apply the good cause standard? What's the difference between sealing and impoundment, except that the standard is very, very different?
Well, as a practical matter, there really is not much difference because the public can't access the record. However, with criminal records, you also have a different problem because your name goes into the CORI system, which means employers will get access to that record or housing authorities, so it has greater implications for the individual. And as I mentioned, in terms of the legislature in enacting CORI reform in 2010 clearly wanted more defendants to be able to seal their criminal records because it wouldn't have reduced the waiting periods.
Right, but I mean, I understand that, but my point's different, I think. I'm not sure if you're getting it. It's much easier to impound a criminal record under our standard than it is to seal a criminal record under this First Amendment standard. Why should that be our law?
I can't think of a good reason as to why that is the law, but I would add that there just are greater implications because just impounding your record wouldn't get the same result for a former defendant because you want to get your name, you want to get your records out of the CORI system that DeCegis is going to
Which impoundment
supply.
wouldn't do.
And you want
Impoundment
to be able
wouldn't
to
do
say
that.
no to the question, do you have a record? You want to be able to say no record, which this provides, and wouldn't provide it with an impoundment.
Right.
Could I ask you, it seems to me that to the extent that the First Amendment, at least Pulaski says the First Amendment creates this presumption, but it's coming from the presumptive openness of courts, and the idea, I take it, the First Amendment right is really so that people can watch to see if courts are doing their business correctly, right?
Yes.
So is there anything to be said for the fact that keeping records open I mean, I guess I'm just wondering how closely does this hew to the underlying First Amendment premise when you are keeping somebody's record open for a really long time with all these collateral consequences as it has vis-a-vis employment? I mean, it just doesn't seem very connected to the underlying First Amendment purpose that openness was supposed to, this is an argument in your favor, by the way, I'm not saying it very well, but I mean, I'm troubled by the disconnect between what the First Amendment seems to me to be seeking, I mean, why it's important in keeping records open and what's involved here.
Yes, that's an excellent point because, you know, the public has a First Amendment right of access to the record, but the public also has other interests. The public has an interest in safe neighborhoods, reduced recidivism, and as taxpayers not having to support former defendants who then have to go on public assistance because they're unemployed. The state also has an interest in public confidence in the legal system, as pointed out in the Commonwealth brief. And in terms of promoting confidence in the legal system, I think as the Lawyers Committee for Civil Rights points out in its brief, the ability to seal one's criminal record is of great interest and affects the vitality and well-being of communities of color because so many blacks and Latinos are impacted by criminal records because of disproportionate involvement in
So
the
it sort of goes to a
criminal record.
balancing, and you're saying here the judge, I mean, at the very least, the judge failed, abused his discretion in the balancing judgment that he made.
Yes, there definitely was an abuse of discretion, again, because in terms of weighing the respective interests, there simply was nothing on the side of the scale that showed there was a benefit to keeping the record open.
Could I ask another question about balancing? I don't remember precisely, in this case, there were a number of years. Is it always the case that there must be a number of years before they're sealing? And if not, would it still be a factor in the judge's mind to say, okay, in terms of the public open access interest, if this has been open for a bit, that serves that interest sufficiently? Is duration before closure, before sealing, a factor that's appropriate to weigh?
Yes, I think the amount of time that's passed, for example, since the time of the arrest to the time of the hearing on the petition to seal the criminal records is probably an important factor. And as pointed out in the amicus briefs, there are recidivism studies showing that most people recidivate within 3 years. And after 7 years, in terms of reoffending, the recidivism rate for somebody to reoffend if they haven't had new cases in that period of time is the same as somebody who has no criminal record. So clearly that is a factor. In this particular case with the petitioner, he was running up against the timeline. In fact, he is eligible to seal his case administratively.
100A or B, under 100A or B?
Yes.
That's
What does that mean? What does that mean? In other words, the timeline will automatically seal the records?
There's no automatic sealing. What
Right.
happens is there is an alternative system, which isn't an issue in this case, even though it was briefed in the
Yeah.
district attorney's brief.
There still has to be a hearing even when the timeline's
There's
expired.
no hearing under the separate Section 100A process. What happens is a petitioner has to wait an awful long time and then submit a form. For a felony, it's at least 10 years. For a
Right.
misdemeanor, it's at least 5. In practice,
Nothing in the interim.
it's probably a lot longer because many times a case may be pending for a few years, and then with sex offenses, at a minimum, it's 15 years.
And the Commonwealth has briefed that and said essentially that piece of the statute also, without the appropriate hearing under Bokaski, is also unconstitutional, right?
Right, but that issue wasn't preserved below, and I think if this court shouldn't take up that issue because the commissioner of probation would need to be involved.
All right.
The attorney general has to be given notice in terms of a constitutional challenge.
Fair
And it-
enough, but let me ask you this question. You say the Commonwealth presented no evidence on the other side of the coin here, but I take it the evidence that your client has suffered or will suffer harm really results to some very serious convictions, not this driving under the influence conviction, just some serious ones that haven't been sealed.
Well, if you go down that road and you force a former defendant to have to prove that each charge results in harm or will result in a job rejection, virtually no one will be able to seal their records.
Wouldn't it be fair for the judge to say, this fellow's got quite the serious record here. It's a while ago, but that's open, and I'm being asked to seal something else more recent. I'm not sure I should do that because of looking at the record overall.
Right. In this case, there were, in terms of what the judge received, what happens is at a criminal record sealing hearing, the probation department hands the judge a copy of the person's carry record. So at this hearing, those cases, the convictions would not have been listed on the defendant's carry at that hearing.
What's
I'm
carry stand for?
confused.
Criminal activity record information?
So that's different than Corey, obviously.
Yes. So that the carry includes pretty much what Corey includes, plus it also includes, for example, civil
So this
restraining
judge wouldn't have the Middlesex convictions before him?
No, and in terms of the Middlesex convictions and the copies of the docket sheets that were appended in a special record appendix to the Commonwealth's brief, those weren't submitted below. There was no discussion whatsoever of these convictions, and they should not have been cited in the brief because there was no mention of them below.
So how could the judge not have copies of these? They're not included?
Well, once
Confused, really.
well, what happens?
If you'd won, what would you, this is going to that question, what would have been sealed if he had been successful? Just the Suffolk County?
Right. The petition to seal lists the cases that would be sealed, so it was only these 2 charges.
Okay.
That was the only thing he was seeking to seal at that time.
Were the other ones sealed?
Yes, Your Honor.
They were sealed.
No, there were
Yes.
some that were open. At least the Commonwealth argues there were some in Middlesex that were still open.
Well, at the time of the hearing, all that the petitioner had on his record were the 2 charges from the Dorchester Division, and he had a few charges also from the Cambridge District Court. And as indicated in the Commonwealth's brief, those also were sealed. at
They
a
were
later time.
sealed.
Yes.
So the DA could get access to them, but
Well,
the public could not. They were already sealed.
Right, the district attorney's office always can get access
Right.
to anything from the probation department. And Section 100D, which was added to Chapter 276, specifically provides that law enforcement, courts, probation have immediate access to sealed records.
Did the serious charges that Justice Cordy is referring to, are they sealed or are they not sealed?
They're sealed. They were already sealed at the time that the petitioner appeared before the judge.
And that was an administrative sealing
was
because
an
he waited the
administrative
10
sealing.
years or whatever he needed to wait?
Yes. So the only thing he had on his record were the 2 charges in this case, and at that time, he also had a few charges in the Cambridge District Court.
Okay.
Those were also non-convictions. So there were
Counsel,
no
we have to leave
convictions
it
on the
there.
record.
Thank you.
Thank you.
Good morning, Your Honors. If it please the Court, Donna Petalano on behalf of the Commonwealth. To clarify, at the time of the hearing, I believe, though the defendant did say that it was in his affidavit, which is part of the record, that it was the Middlesex convictions that had caused him not to get public housing. So he was still feeling the effects, or that was part of the presentation that he gave to the judge when he asked for the sealing of these.
When the Commonwealth asked to impound a document, do you agree that there is a constitutional entitlement of the public to have access to that document?
Yes, but the difference, you asked the question, why the good cause standard with impoundment versus sealing? I haven't researched that specifically, but from what I understand, and this court discussed in Adams, that there's no presumption, impoundment does not carry a presumption that the order continues. In fact, if you get an ex parte order under impoundment, it expires automatically 5 days after that order is issued.
But it can be a non-ex parte and it can continue indefinitely.
That's true, it
And is the
can.
Commonwealth prepared to accept the standard that whenever it seeks to impound a search warrant or other public document, that it must show a compelling government interest and that impoundment is the least restrictive alternative?
No, and the other difference, Your Honor, is that in impoundment, both parties know what is going on in the case. And the rules, which are under review right now, but the rules of impoundment procedure allow for the parties to come before the judge at any time in order to reevaluate whether the good cause standard still exists. So often, a search warrant that has been impounded is often then, when the case begins in the trial court, is then and the affidavit, let's say, is disclosed to defense counsel, the impoundment order ends.
So, but no, with regard to impoundment, we've never said that there's a First Amendment right, except in the Doe case. We've said that there's a common law presumption of openness. I guess I'm trying to figure out why we are imposing in this very restrictive First Amendment standard that is much tougher than we apply to impoundment, even when impoundment may be indefinite.
Well, it's because of the presumption of openness that has happened, that has occurred since the founders. And the reason why is under 100A and 100C here, every court document will become sealed at some point automatically, and it is automatic. It just requires one form. There is no judicial determination.
Not under 100C.
Not under paragraph 2, but under paragraph 1, it is automatic. There's no judicial hearing at all if it resulted from a not guilty, a no bill, no finding of probable cause. So it's only under paragraph 2. But since Pokaski, and when Pokaski said that 100C was unconstitutional, then they began the hearings and the automatic sealing ended. But from what we understand, from what the Commonwealth understands, there is still automatic sealing. In fact, there are sealings that occur with just the Department of Probation. There is no judicial determination
You mean
at
under
all.
100C or 100A?
I'm sorry, 100A, Your Honor, I apologize.
Okay, but you haven't brought any action for declaratory judgment on that. How can we possibly decide 100A when it's not even before the court?
No, we haven't, Your Honor. And part of the issue is we're never party to those sealings. We're not.
You have the power to issue, to seek declaratory relief. You do have lawyers. So how can you possibly ask us to be deciding that issue?
Well, even if we just focus on 100C here, Your Honor, it's unconstitutional. Pokaski, as Justice Link pointed out, since Pokaski, 100C has barely
First
changed.
Circuit, right? It's not Supreme
It
Court.
is, but this court followed it in Doe. And it's really, it's the conflict of the defendant's interests in privacy versus the constitutional right of the public to access.
But
of
let's
these-
just talk about that constitutional right of the public to access. Do you agree that that comes from things like press enterprise, it's sort of the open court?
Yes.
It's not for employers to get records of people so they can deny them jobs, right?
Right, Your Honor, but the end result of having a sealing would be that the public doesn't have access to those records. It's somewhat circular, I understand, and
Well,
and
I'd
perhaps
suggest that there's some balancing that goes on.
perhaps what this court should be doing with this case is enumerating factors for judges to consider when they have the two-step hearing, because that really has not been developed. And I think all of the parties, all of the stakeholders here would definitely benefit from having more factors. The amicus brief provides some factors, as does the EEOC memo that we have in our record appendix, in order to have the judges make that balancing determination and decide whether or not the defendant's interest in privacy outweighs the public's right, constitutional right to access to these records.
And is it your view that that is materially different from a good cause standard?
Yes, Your Honor.
Now, in Doe, which was basically this court's response to what to do with 100C after Pokaski, the court said that Pokaski really sort of depended on the act of sealing being rare or extraordinary rather than commonplace, because otherwise there was no way to sustain the strong presumption that court records would be open to the public. So do you see a tension or one that can be reconciled between plainly the increasing legislative desire made even more compelling by the Corey reforms, where more people have access to criminal record information, and yet at the same time, wanting to give greater ability to seal the court records, so that it's a question of, to me, it looks like a tension, a significant tension between the desire to seal more court records and the strong presumption that court records are going to be open.
Right.
That and to what extent are we bound by Pokaski?
I think under Doe, you're bound by Pokaski.
Well, could we revisit this?
You could, Your Honor, but the problem is that the First Amendment hasn't changed. The legislative policy and the goals of the legislature have changed, certainly, or have become more robust than they were at the time of Pokaski. But there are other ways to effectuate the legislative goal. Have tax relief for employers who hire people who have Corey records. That doesn't offend at all the First Amendment. Have public education about how all of the things that are put forth in the defendant's brief and the amicus brief, and say that there are compelling reasons why employers should hire people who have Corys. Ultimately, what's going to happen, I don't even think that the the goal here is going to be reached. Because what people will see when they get a query is that this, and the exact language is, there is at least one sealed case on file, which appears on this person's, on Peter Pon's query right now.
That'll be seen by an employer?
It's on the query. If they run a query check,
Oh,
from what I
an
understand,
employer will see that?
that there is one.
Or the court or the prosecution or the police will see
Well,
that?
I apologize, Your Honor. I'm not sure. That's the query that we receive.
Right, you get that, and it tells
has-
you, but I don't think it tells an employer that there's a sealed record. That would be, there's something that you don't know about.
But
Would
he-
not help a person seeking employment.
Even so, the record below on Peter Pon is illuminating, because he was asked about whether or not he had been incarcerated. And he could answer no record, but there is a question as to whether or not these query sealings will actually affect the relief that the legislature is looking for. And again, I go back to the problem is when you have that tension, they need to find a way to affect these policy changes without violating the First Amendment.
Let me ask you this. What if the legislature were to say, all right, fine, we're not going to seal any records, but we're going to take records off query at a certain point? Same standards, 10 years after a felony, 5 years after a misdemeanor, no intervening, we're taking them off query. They're available at the courthouse. Somebody wants to go find them and figure it out and try to, but we're taking them off query. Solution?
I thought about that, Your Honor. I'm not sure it's a solution. It depends on how,
And the First Amendment doesn't require that these things be available on the internet. It
no,
doesn't require
you're
any of
absolutely
that.
right. It just requires that it be available. The issue there really is you would also have to provide defendants the opportunity to answer no record. And I think they can only do that
Probably.
if it's sealed.
Now, is it your view
Unless
that,
the legislature changed that as well.
Yes.
is it your view that the fact that juvenile records are impounded, not available to the public, is a constitutional violation as well?
Because the juvenile court has different goals, perhaps not. But I think that there.
But it would still be the same standard? It must
I
be a
think there is an-
compelling government interest, and it must be the least restrictive alternative, and so if we,
Hearings are closed?
And I think that makes a difference as well. The compelling governmental interest is already met because the hearings are closed. And certainly, that's not something that we're arguing, Your Honor.
I understand, but I mean, but has any other circuit adopted the Pokaski view that there is a First Amendment right?
Yes, Your Honor, and those cases are cited in the Commonwealth's brief.
Has any state advanced the proposition that we do have a compelling state interest in seeing that people are employed and not discouraged or interfered with in their employment searches if they have been found not guilty or a case against them has been dismissed? Is that a compelling state interest?
I believe that is a compelling state interest, but that still would get you to the hearing, Your Honor, where there's a balancing where the judge can consider factors. And the language in Doe is that the judge consider all relevant information. So in addition to providing factors for a judge who has to undergo this two-step hearing process, to provide what all that relevant information is. Perhaps the way to deal with Pokaski and Doe at this point is to provide the judges with some guidance as to an expanded amount of information that they can consider, and that can be the age of the case, the age of the defendant when he committed the crime, whether, what information has come to light since then, what steps towards rehabilitation has that person taken. Here, what seems to have happened is that there was the focus on whether or not the harms flowed from this particular entry in the defendant's query. And perhaps it should instead be expanded to include other factors. But it cannot be an automatic sealing. Pokaski and Doe still say that the First Amendment is exactly the same. The defendant's interests in privacy just don't trump the public's constitutional right to access to these judicial records.
Now, the standard that Pokaski applies is the same standard used to close a courtroom.
Yes.
And,
And the
and your view that the same standard should apply for the sealing of records as for the closing of a quorum during the course of a trial? That is a comparable restriction on?
Well, the closing of the courtroom is in a different footing in the sense that, and I think it is Pulaski that discusses this, though it may be Doe, that it's still an ongoing proceeding as opposed to a closed proceeding. So in essence, they were talking about the public's right, the press's right to access to that proceeding. And because it's still ongoing, there's still news to be made, that there's a heightened interest to the press to have that access to the courtroom, that the presumption of an open courtroom be fulfilled in those instances. So it stands in slightly different footing because of the timing
I take it
aspects
on
of
that
it.
when there's a closed courtroom, I mean, assuming it's not a juvenile case, the record of what happened during that period of time, of course, is made public.
Absolutely.
Now, you agree there is a compelling government interest in the sealing of records.
Yes, Your Honor.
So the only issue is whether it's the least restrictive alternative?
Yes, Your Honor.
And what must somebody do to show that it's the least restrictive alternative? What is a less restrictive alternative?
Well, that's part of what I'm talking about with the factors and what all the relevant information should be, and that I think this case would be important to provide that guidance.
Okay, but that goes to whether it's compelling, not whether it's the least restrictive alternative.
Well, as far as the least restrictive alternative for that individual, part of it it actually does go to those factors, because they're talking about, when you talk about the time, for instance, how long has the public been able to access information about this defendant's interaction in the criminal justice system? That's part of whether or not it's least restrictive.
But why hasn't the legislature already made a finding, a legislative fact finding that, what is it, 10 years for a felony, 5 years for a misdemeanor, and we can do it right away if the person's been found not guilty? That's the compelling state interest right there.
I can't answer about why. I wish the legislature would pay more attention to the court's opinions, but that's not within our...
A lot of us feel that way. Maybe
That's off the record, right?
that's a good place to stop. Thank you very much.
Thank you, Your
We'll take our
Honors.
morning recess.